State Test 11, Commission Duties and Powers 11.1, c. 5 members. The Nevada Real Estate Commission has 5 members. CNRS 645.050. 11.2, b. 1 is required to be from Washoe County. Effective July 1, 2015, 3 commissioners must be from Clark County, 1 from Washoe County, and 1 from the remainder of the state. UB 410, not yet codified. 11.3, b. Appointed by the governor. Nevada Real Estate Commissioners are appointed by the governor. CNRS 645.050. 11.4, b. 3 years. Nevada Real Estate Commissioners serve 3-year terms. CNRS 645.060. 11.5, a. 2 consecutive terms. A Nevada Real Estate Commissioner can only serve 2 consecutive terms. 11.6, b. At least a Nevada Real Estate Broker Salesperson. A Nevada Real Estate Commissioner must be a broker or a broker salesperson. A broker must have 3 years of active experience immediately preceding appointment, and a broker salesperson must have 5 years of active experience immediately preceding appointment. 11.7, d. 3 years after serving 2 consecutive terms, a person must wait 3 years before serving another term as a Nevada Real Estate Commissioner. 11.8, a. Adopts regulations. The legislature enacts statutes and courts adjudicate complaints. The Real Estate Commission adopts regulations to implement and interpret NRS 645. 11.9, c. The Nevada Real Estate Commission. The Nevada Real Estate Commission conducts disciplinary hearings when licensees are charged with violating license law. 11.10, c. The Nevada Real Estate Commission. The Nevada Real Estate Commission regulates real estate education in Nevada. 11.11, d. Advisory. Although the Real Estate Commission has a lot of authority, it acts in an advisory capacity to the Real Estate Division. 11.12, b. The Nevada Real Estate Division. The Nevada Legislature, through an enabling statute, has delegated the administration of the real estate law to the Real Estate Division, with the Real Estate Commission acting in an advisory capacity. 11.13, b. Administrator. By statute, the Chief Executive Officer of the Real Estate Division is called the Administrator. 11.14, c. Cannot be affiliated with a real estate brokerage firm. Real estate commissioners must be affiliated with a brokerage, but the administrator cannot be affiliated with a brokerage. 11.15, a. Whether the licensee has treated all parties fairly. This is one of the factors that can be considered pursuant to NAC 645.605. 11.16, d. Whether the licensee has communicated with his or her client on a regular basis. It is important for a licensee to communicate frequently with a client, but it is not a factor used to determine whether the licensee has engaged in misconduct. 11.17, a. Whether the licensee has a college degree. A licensee's level of education is not a factor in determining whether a licensee has engaged in misconduct. 11.18 d. No, he got assistance from a residential agent and disclosed his lack of experience to the client. A licensee is not subject to discipline for acting outside his area of competence if he discloses his lack of experience or lack of competence to the client and obtains assistance from a qualified authority. Carl did both. However, Carl could still be subject to a lawsuit for the mistakes that were made. 11.19 a. Yes, Betty failed to ascertain pertinent facts about the property. A licensee can be disciplined for failure to ascertain all pertinent facts about the property which is the subject of the transaction. Betty should have researched the client's question before answering it. 11.20 d. Yes. Sally must disclose her ownership interest in the seller LLC regardless of how small the ownership interest. The fact that she is charging a minimal commission is irrelevant. The fact that she does not expect any profit does not negate her duty to disclose. 11.21 d. Yes, an expiration date is required in all brokerage agreements. It is illegal to write a brokerage agreement that lacks an expiration. 11.22 c. $25,000/$100,000 The maximum recovery from the Education Research and Recovery Fund is $25,000 per claim and $100,000 per licensee. 11.23 a. 5 years. A broker must retain records for 5 years. Other licensees do not have record retention requirements. 11.24 a. Broker salesperson. There are 3 basic types of real estate licenses in Nevada: broker, broker salesperson, and salesperson. 11.25 d. Yes, the expectation of payment is enough. Rhonda is helping Brian with a real estate transaction with the expectation of being paid. She needs a license. NRS 645.030. It makes no difference whether she does not get paid, or does not have an agreement to get paid. 11.26 a. No, Ryan must have a real estate license to be paid for performing the services of a real estate licensee. An agreement to pay an unlicensed person is unenforceable. 11.27 c. Someone transacting mining claims. Mining claims are exempt from Nevada's real estate license law. An appraiser, home inspector, or loan officer must have a real estate license to engage in the activities of a real estate licensee. 11.28 d. is exempt from the Nevada real estate licensing requirement. An attorney, when performing her duties as an attorney, is exempt from the license law. 11.29 b. Property management and business brokerage each require a real estate license and a special permit. The permit is not needed for the other activities listed. 11.30 c. Have a designated broker. Business entities are required to have a designated broker. For a partnership, it must be a partner. For a corporation, an officer. For a limited liability company, the manager. 11.31 B. No, she is not being compensated or expecting any compensation. A real estate license is only needed when someone works for compensation or the expectation of compensation. Sheila cannot obtain a real property management permit without a real estate license. 11.32, c. 90 hours of pre-license education, including 18 hours of Nevada law, are required to obtain a salesperson's license. 11.33, b. 64 credits. 64 college credits are required to obtain a real estate broker's license. 16 credits are obtained for every 2 years of active experience. 11.34, b. Cannot engage in any activities that require a license. The person with an inactive license cannot engage in any activities that require a license. Property management activities require a real estate license and property management permit. 11.35, a. 12 months. An initial license is valid for 12 months. To renew, the licensee must complete the prescribed post-license course. 11.36, a. 24 months. After the first renewal, a license is valid for 24 months. To renew, the licensee must complete 24 hours of continuing education. 11.37, d. Placed on inactive status. When a broker's license is expired, suspended, or revoked, the licenses of affiliated licensees become inactive. 11.38, b. We sell MFast broker. When a licensee changes brokerage affiliations, he employing broker must notify the division within 10 days and submit the licensee's license. The division will send the license to the new broker. If the brokers agree in writing, the licensee may carry his license to the new broker. State Test 12, Property Disclosures, Record Keeping, Contracts, Advertising. 12.1, c. At least 10 days before the close of escrow, the seller's real property disclosure form must be delivered to the buyer. By law, at least 10 days before the close of escrow. This time period is often shortened by agreement of the parties. 12.2, b. 5 calendar days after receipt of the resale package, a buyer has until midnight of the 5th calendar day to rescind the transaction. 12.3, a. Resale package. By statute, the collection of documents given by a seller to a buyer in a common interest community is called the resale package. It is sometimes also referred to as the HOA docs. 12.4, d. 4 working days. Although it is an unusual number, a buyer has 4 working days after receipt of the seller's real property disclosure form to rescind the transaction. 12.5, a. Seller. The seller's agent can help explain the document to the seller, but the seller must complete the seller's real property disclosure form. 12.6, b. Disclose in writing that the defect has gotten worse. If, after delivery of the seller's real property disclosure form, a new defect is discovered, or a disclosed defect has worsened, the seller must disclose the change to the buyer in writing before conveyance of the property. 12.7, a. Residential Disclosure Guide. The Residential Disclosure Guide is given by licensees to prospective buyers and sellers. Other documents listed are given by the seller to a buyer. 12.8 C. Residential sales transactions only. The seller's real property disclosure form is only required in residential sales. 12.9 D. In all residential sales transactions where the property is located in a common interest community. The resale package is required in all residential sales transactions where the property is located in a common interest community. The resale package is in addition to, and not in lieu of, the seller's real property disclosure form. 12.10 A. Minutes of Executive Board Meetings. Minutes of Executive Board Meetings are no longer a required component of the resale package. 12.11 A. The unit owner, seller, or his agent. The law requires the unit's owner, or his or her authorized agent, to furnish to a resale package to the buyer at the owner's expense. The unit owner must request the homeowners association to provide the necessary documents for inclusion in the package. 12.12 B. 10 days. The homeowners association has 10 days to deliver the contents to the owner after a proper written request. 12.13 B. 5 business days. The purchaser may, by written notice, cancel the contract of purchase until midnight of the 5th calendar day following the date of receipt of the resale package. 12.14 B. Resale package. The resale package is sometimes referred to as the homeowners association documents. 12.15 C. $9,000 plus attorney's fees and costs if the buyer does not receive a seller's real property disclosure form and later discovers a defect of which the seller was aware. The buyer can obtain treble damages plus attorney's fees and costs. 12.16 C. Open range disclosure. When property is located adjacent to the land where domesticated animals are allowed to roam or graze, the seller must give to the buyer, before the buyer signs an offer, an open range disclosure form. 12.17 B. 5 years. A real estate broker must retain real estate transaction records for 5 years. 12.18 B. No, a broker must number each real estate transaction consecutively or index to permit audit by a representative of the real estate division. 12.19 A. 5 calendar days. A salesperson or broker salesperson must provide any paperwork to the broker with whom she is associated within 5 calendar days after that paperwork is executed by all the parties. 12.20 D. Salespeople are not required to maintain transaction records. Brokers, not salespeople or broker salespeople, are responsible for maintaining records. 12.21 A. In the state of Nevada, a complete record of each real estate transaction along with trust account records must be kept in the state of Nevada. It is not required that the records be in electronic format. 12.22 C. A real estate salesperson may not be the only signatory on a trust account. A real estate salesperson may be a cosigner of an account with his or her real estate broker, but may not be the sole required signatory. 12.23 D. This is insufficient because he must advise the division of the exact location of the records. The real estate broker must give written notice to the division of the exact location of the records. 12.24 A. the records cannot be moved until the real estate division is notified of the new location. A broker does not need permission from the real estate division to move her records, but the records cannot be moved until the real estate division is notified of the new location. 12.25 b. 2 accounts. A property manager must maintain at least 2 trust accounts. One for rental operations and one for security deposits. 12.26 c. 30 days. Trust accounts must be reconciled monthly within 30 days after receipt of the bank statement. 12.27 c. By any real estate licensee. Although it is called a broker price opinion, it can be prepared by any real estate licensee. 12.28 a. In lieu of an appraisal for approval of a mortgage. A broker price opinion can be prepared for a seller, a buyer, or a lien holder but cannot be prepared in lieu of an appraisal for approval of a mortgage. 12.29 d. The legal description of the property. A brief description of the property is required for a broker price opinion, but a legal description is not. 12.30 b. 1 business day. A licensee must give the broker or escrow holder the earnest money within 1 business day. The broker has until the next banking day to deposit the money in the broker's trust account. 12.31 b. Pay all or a portion of it to the seller. Although it is rarely done, unless the purchase agreement provides otherwise, a broker can pay all or a portion of an earnest money deposit to a seller. 12.32 d. Disclose the name of the brokerage firm. In all real estate advertising, the name of the brokerage firm must be disclosed. The other items are typically included but not legally required. 12.33 c. With prominence. In print advertising, the name of the brokerage firm must be clearly identified with prominence. The real estate division will consider style, size, and color, type of font and location of the brokerage firm name. 12.34 c. Richard can only use his licensed name and advertising, not a nickname. In advertising, a licensee may use only his licensed name. Nicknames are not allowed. 12.35 a. Her advertising must be done under the direct supervision and in the name of the brokerage with whom the licensee is associated. All advertising must be done under the direct supervision and in the name of the brokerage with whom the licensee is associated. Sandra's experience and status as a broker salesperson are irrelevant. 12.36 d. For sale by owner agent. A licensee cannot use the words for sale by owner. The phrase for sale by owner agent is acceptable. 12.37 b. All members of the team or group must be associated with the same broker. All members of a team or group must be associated with the same broker. There is no requirement that a team or group to be supervised by a broker salesperson. A team must have more than one licensee and the name of the team or group must include the last name of one member of the team or group. 12.38 d. It must be at least 4 feet by 3 feet. There is no provision specifying the minimum dimensions for a broker's sign. 12.39 a. Upon request by the division, a photograph of the broker's sign is only necessary upon request by the division. 12.40 C. Advertising must include the name of the brokerage firm. Advertising on the Internet is subject to the same regulations as print advertising and therefore must include the name of the brokerage. 12.41 D. Not mentioned in Nevada statutes or regulations. Social media is not mentioned anywhere in Nevada statutes or regulations. State Test 13, Agency and Brokerage, Special Topics 13.1, C. Ethics of the real estate profession. Every real estate broker is required to teach the licensees associated with him or her the fundamentals of real estate or timeshare practice, or both, and the ethics of the profession. 13.2, B. A broker salesperson. A real estate broker may use a real estate broker salesperson to assist in administering the office, as long as the broker does not relinquish overall responsibility. There is no experience requirement for the broker salesperson. A salesperson may not be used to assist in administering the office. 13.3, B. No, but policies and procedures must be established. A broker must establish policies and procedures, but there is no specific requirement to have a written policies and procedures manual. 13.4, D. The brokerage firm's gross revenues. A brokerage firm's gross revenues is not listed in the regulations as one of the factors that must be considered when establishing rules, procedures, and systems. The other factors are specifically listed. 13.5 A. A system for monitoring compliance with policies, rules, and procedures. A system to monitor compliance with policies, rules, and procedures is a specific regulatory requirement. The other answers might be good ideas, but they are not specifically required. 13.6 D. A statement that the broker will supervise associated licensees. A broker can enter an independent contractor agreement with an associated licensee, but that agreement must include the supervision of the broker over the licensees. 13.7 C. A broker's license. Regardless of any other circumstances, Brian is not entitled to any compensation until he first proves that he has a broker's license. 13.8 D. The referral fee should have been paid through Keith and Paula's broker. Referral fees among real estate licensees are legal in Nevada. However, a licensee can only be compensated by the broker or owner-developer with whom the licensee is associated. Payment of the referral fee in this case should have flowed through the broker. 13.9 A. They are negotiable between the broker and the client. Fees are negotiable between the broker and the client, although a salesperson or a broker salesperson may negotiate on behalf of the broker. Establishing fees by agreement among brokers would be an antitrust, price fixing, violation. 13.10 B. Duties owed by a Nevada real estate licensee form. Nevada's agency disclosure form is called the Duties Owed by a Nevada Real Estate Licensee. 13.11 C. The broker and the client. The broker and the client are the only parties to a brokerage agreement. A salesperson or broker salesperson acts on behalf of the broker. 13.12 b. Consent to act form. To obtain the informed, written consent to act for more than one party to a transaction, the parties must sign a form called the consent to act. 13.13 a. 1. Duties owed by a Nevada real estate licensee. 2. The brokerage agreement. The duties owed by a Nevada real estate licensee form must be signed before the client signs any other document. 13.14 c. Duties owed by a Nevada real estate licensee. The duties owed by a Nevada real estate licensee form must be given to each client and any unrepresented party to the transaction. A for sale by owner seller is an unrepresented party to the transaction. 13.15 d. It is not a contract for services. Immediately beneath the title of the document it is noted that the duties owed by a Nevada real estate licensee form is not a contract for services. 13.16 b. Make arrangements with the client so that the duties owed by a Nevada real estate licensee form can be signed before the listing agreement is signed. The duties owed by a Nevada real estate licensee form must be signed before the client signs any other document. 13.17 d. In the purchase agreement, the confirmation of agency relationship must be separate from the disclosure in the duties owed by a Nevada real estate licensee form. The confirmation is often made in the purchase or rental agreement. While the brokerage agreement can create an agency relationship, it does not serve as the confirmation for both parties. 13.18 b. It can be oral or written. Some states require a brokerage agreement to be in writing. In Nevada, a brokerage agreement can be oral or written. 13.19 c. Client and a broker. Only a broker can enter a brokerage agreement with a client. Salespeople and broker. Salespeople act on behalf of their broker when working with clients. 13.20 a. Property management agreement. A property management agreement is specifically excluded from the definition of a brokerage agreement. 13.21 b. From the client or another person. Allowing the broker to accept compensation from someone other than the client facilitates broker fee sharing agreements through the multiple listing service. 13.22 c. Be in writing. A brokerage agreement which includes a provision for an exclusive agency representation must be in writing, be signed, have a definite termination date, and cannot have an automatic extension clause. 13.23 d. Carla's broker and Chandra. The parties to a brokerage agreement are the broker and the client. Salespeople act on behalf of their brokers. 13.24 a. Must be in writing. Unlike some other brokerage agreements, an advance fee listing must be in writing. 13.25 d. Yes. Any oral statement made to induce a person to enter an advance fee agreement becomes a part of the agreement. A broker cannot rely solely on the terms in a written advance fee listing. Any oral statement made to induce a person to enter an advance fee agreement becomes a part of the agreement. 13.26 d. Yes, if she should have known about the defect, a real estate licensee has a duty to disclose material facts she knows, or which through the exercise of reasonable care and diligence, should have known relating to the property. The licensee's duty is independent of the seller's duty to disclose defects in the seller's real property disclosure form. A licensee specifically does not have a duty to conduct an investigation of the condition of the property. 13.27 b. Disclose the leak to any buyer. A real estate licensee has an independent duty to disclose material facts relating to the property. Facts relating to the condition of the property are not confidential. 13.28 a. Legally liable for her own conduct. A real estate licensee is always legally liable for her own conduct. A broker is vicariously liable for the conduct of all associated licensees. 13.29 a. Non-agency. Nevada does not recognize any non-agency relationships with a client. A broker always has some kind of agency relationship with a client. 13.30 b. Is not required to have a real estate license. A personal assistant in Nevada is not required to have any kind of license, permit or certificate. 13.31 b. The listing agent must disclose that Tiffany's grandmother is contributing to the commission, but she is not required to disclose the amount. A real estate licensee is required to disclose each source of compensation but is not required to disclose the amount. 13.32 a. Yes. A licensee's duty to disclose material facts relating to the property cannot be waived. The duty of confidentiality does not extend to material facts relating to the property. Even a small leak could be a material fact to a buyer. 13.33 c. No, it is not a material fact relating to the property. A licensee owes a duty to all parties to disclose material facts relating to the property. The seller's desperate financial situation might be a material fact, but it does not relate to the property. 13.34 c. Yes. It is a material fact concerning the transaction. A licensee owes a duty to her client to disclose material facts she knows concerning the transaction. There is no legally recognized duty of confidentiality owed to a non-client friend. 13.35 d. Any information that could affect a person's decision. A working definition of a material fact is any information that could affect a person's decision. Material facts relating to the property must be disclosed to all parties. Material facts concerning the transaction must be disclosed to a client. 13.36 b. Yes. He must disclose it to all parties to a transaction. A real estate licensee must disclose the fact that he is a principal in the transaction or has an interest in a principal to the transaction. The size of Tom's small percentage interest in the corporation is not relevant. 13.37 b. Yes. A Nevada real estate licensee must disclose the fact that she is a principal in the transaction. It does not matter where the property is located. 13.38 b. Acting for more than one party to the transaction, i.e., dual agency. Marjorie's broker is representing the buyer and seller without using an assigned agency. This means Marjorie is also acting for the buyer and seller and is, therefore, a dual agent. 13.39 C. He must advise the seller that his agency relationship to the seller has changed. Bill started as a single agent for the buyer. His relationship changed when Bill's broker assigned Bill to represent the seller. Bill is now an assigned agent and not a single agent. A licensee must disclose any changes in the licensee's relationship to a party to the transaction. 13.40 A. He must disclose that he is acting for more than one party to the transaction and obtain the necessary written consent. Harvey cannot be an assigned agent unless his broker makes an assignment. Harvey is not required to refer one of the clients because acting for more than one party to the transaction is allowed in Nevada. Harvey must disclose that he is acting for more than one party to the transaction and obtain the necessary written consent. 13.41 C. Transactional brokerage. A transaction broker represents neither party as an agent, but works to assist both parties equally. In Nevada, a real estate licensee must represent someone in the transaction. Transactional brokerage is not recognized. 13.42 A. Consent to act form. Assigned agency is not being practiced, so Nancy and Pam are acting for more than one party to the transaction, i.e. multiple representation. They must obtain signatures on the consent to act form. The other forms don't exist. 13.43 A. Broker. In Nevada, only a broker can independently represent a client. The other licensees act on behalf of a broker to represent a client. 13.44 C. Reasonable skill and care. As to all parties to a real estate transaction, a licensee owes a duty to exercise reasonable skill and care. Fiduciary duties are only owed to a client. 13.45 A. All parties to a transaction. The duty to disclose all sources of compensation is owed to all parties to a transaction, including a non-client. 13.46 B. The client. A duty to disclose material facts relating to the property is owed to all parties to the transaction. A duty to disclose material facts concerning the transaction is only owed to a client. 13.47 D. Advise the client to obtain expert advice. Desiree must advise the client to obtain advice from an expert relating to matters which are beyond the expertise of the license. 13.48 D. Duties owed by a Nevada real estate licensee form. The duties owed by a Nevada real estate licensee form is the only one listed that specifically must be given to the client and an unrepresented party. 13.49 B. To obtain authorization for a real estate broker to act for more than one party to a transaction. Before a broker can act for more than one party to a transaction, the broker needs the informed written consent of all parties. The consent to act form is used to advise the clients of the conflict of interest and obtain their written consent to the multiple representation. 13.50 C. To conduct an investigation of the condition of the property. By statute, a real estate licensee does not have a duty to conduct an investigation of the condition of the property. All of the other choices are specific statutory duties. 13.51 d. No, a licensee does not have a duty to conduct an independent inspection of the financial condition of a party to the real estate transaction. By statute, a real estate licensee does not have a duty to conduct an independent inspection of the financial condition of a party to the real estate transaction. 13.52 a. Maintain confidentiality. A real estate licensee owes a duty of confidentiality to his client but not to the other parties to the transaction. The other duties listed are owed to all parties to the transaction, not just a client. 13.53 b. His client a duty to disclose material facts concerning the transaction is owed to a client. A duty to disclose material facts relating to the property is owed to all parties to the transaction. 13.54 c. He must present it to Francis. All offers made to or by a client must be presented until an escrow closes. 13.55 d. Yes. She must present all offers. A licensee must present all offers made to or by a client without regard to the amount offered. 13.56 a. Consent to act. The consent to act form is needed to act for more than one party to a transaction. It discloses the conflict of interest and authorizes the representation. The duties owed by a Nevada real estate licensee is required in all transactions, but it is a disclosure form only and does not authorize acting for more than one party to the transaction. The other forms listed do not exist. 13.57 c. As soon as practicable. Two statutes cover when an offer must be presented or tendered. One states as soon as practicable and the other says promptly. There is no specified time period. 13.58 b. 35 or more land must be divided into. Oregon proposed to be divided into 35 or more lots before Nevada's subdivided land law is applicable. 13.59 a. Public offering statement. A public offering statement must be reviewed with every prospective original buyer of a timeshare. 13.60 b. The doctrine of prior appropriation. This means that the first person to use water or divert water for a beneficial use or purpose can acquire individual rights to the water. 13.61 c. Timeshares and campground memberships. A sales agent, sometimes called a timeshare sales agent, is a license level lower than a salesperson. Under the supervision of a project broker, a sales agent can only sell timeshares and campground memberships. Simulation test, Nevada License Examination Simulation Test S1. B. Trade fixtures that are personal property. Trade fixtures are items of a tenant's personal property that the tenant has temporarily affixed to a landlord's real property in order to conduct business. Trade fixtures may be detached and removed before or upon surrender of the leased premises. Should the tenant fail to remove a trade fixture, it may become the property of the landlord through accession. Thereafter, the fixture is considered real property. S2. C. Severance and affixing. Severance is the conversion of real property to personal property by detaching it from the real estate, Affixing, or attachment, is the act of converting personal property to real property by attaching it to the real estate, such as by assembling a pile of bricks into a barbecue pit, or constructing a boat dock from wood planks. S3. D. Absolute fee simple estate. The fee simple freehold estate is the highest form of ownership interest one can acquire in real estate. It includes the complete bundle of rights, and the tenancy is unlimited, with certain exceptions. The fee simple absolute estate is a perpetual estate that is not conditioned by stipulated or restricted uses. S4. C. The estate may revert to a grantor or heirs if the prescribed use changes. The defeasible fee estate is perpetual, provided the usage conforms to stated conditions. Essential characteristics are: the property must be used for a certain purpose or under certain conditions, and, if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. S5. A. Conventional life estate. A conventional life estate is a freehold estate that is limited in duration to the life of the owner or other named person. Upon the death of the owner or other named individual, the estate passes to the original owner or another named party. A legal life estate is created by law as opposed to a property owner's choice. S6. A. A condominium owner owns a unit of airspace whereas the co-op owner owns a proprietary lease. The owner of a condominium has a fee simple ownership interest in his/her unit and its airspace. Whereas, a co-op owner has a leasehold, not fee simple, interest with the property's corporation. Since the corporation owns an undivided interest in the cooperative property, debts and financial obligations apply to the property as a whole, not to individual units as in a condominium. S7. D. Trustor, trustee, and beneficiary. In an estate in trust, a fee owner, the grantor or trustor, transfers legal title to a fiduciary, the trustee, who holds and manages the estate for the benefit of another party, the beneficiary. S8. C. Fee simple ownership of the airspace in a unit and an undivided share of the entire property's common areas. A condominium is a hybrid form of ownership of multi-unit residential or commercial properties. It combines ownership of a fee simple interest in the airspace within a unit with ownership of an undivided share, as a tenant in common, of the entire property's common elements, such as lobbies, swimming pools, and hallways. S9. A. The date of recordation. Among junior liens, date of recording determines priority. The rule is, the earlier the recording date of the lien, the higher its priority. For example, if a judgment lien is recorded against a property on Friday, and a mortgage lien is recorded on the following Tuesday, the judgment lien has priority and must be satisfied in a foreclosure ahead of the mortgage lien. S10. B. A state in which a mortgagor retains title to the property when a mortgage lien is created. In lien theory states, laws give a lender on a mortgaged property equitable title rather than legal title. The mortgagor in a lien theory state retains legal title. S11. B. Transfers with the property. The term appurtenant means attaching to. An easement appurtenant attaches to the estate and transfers with it unless specifically stated otherwise in the transaction documents. S12. C. Giving constructive notice of one's rights and interests in the property. Recorded instruments may include deeds, mortgages, liens, easements, sale contracts, and marriage, probate and tax records. The primary purpose of recording and maintaining records of these instruments is to provide constructive notice of the conditions of a property's title, who owns it, who maintains claims against it. S13. C. A chronology of successive owners of record of a parcel of real estate. Chain of title refers to the succession of owners of record dating back to the original grant of title from the state to a private party. It is thus more than a mere list, it is a chronological list as reflected in title records. S14. C. Title insurance. A title insurance policy indemnifies the policyholder against losses arising from defects in the title and is thus generally accepted as the best evidence of marketability after a Turin certificate, which is not available in every jurisdiction. A signed deed is no evidence of marketability, only of an intent to convey. Title. An attorney's opinion and a title certificate, while forms of evidence of marketability, do not guarantee clear title or offer any protection against a defective title. S15. C. Percentage lease. A percentage lease allows the landlord to share in the income generated from the use of the property. A tenant pays percentage rent, or an amount of rent equal to a percentage of the tenant's periodic gross sales. S16. D. Net lease. A net lease requires a tenant to pay for utilities, internal repairs, and a proportionate share of taxes, insurance, and operating expenses in addition to rent. S17. B. The leased property is foreclosed. A foreclosure extinguishes all prior interests in a property, including a leasehold. S18. C. The construction conforms with applicable building codes. Building inspectors inspect a new development or improvement for code compliance. If the work complies, the municipality or county issues a certificate of occupancy which officially clears the property for occupation and use. S19. B. Takes title subject to the same restriction. Deed restrictions attach to the title of the property. Therefore, the restriction passes to the new buyer. S20. A. She has the right to repossess the property because the grantee has violated the condition. A deed condition may restrict certain uses of a property, much like a deed restriction. However, violation of a deed condition gives the grantor the right to retake possession of the property and file suit for legal title. S21. A. To create a consistent, unchanging standard for identifying a property's unique location. A legal description of real property is one which accurately locates and identifies the boundaries of the subject parcel to a degree acceptable by courts of law in the state where the property is located. The general criterion for a legal description is that it alone provides sufficient data for a surveyor to locate the parcel. A legal description identifies the property as unique and distinct from all other properties. S22. B. They identify an enclosed area, beginning and ending at the same point. The metes and bounds description always identifies an enclosed area by starting at an origination point, called point of beginning, or POB, and returning to the POB at the end of the description. S23. A. Is void. By changing any of the terms of an offer, the offeree creates a counter-offer, and the original offer is void. At this point, the offeree becomes the offerer, and the new offeree gains the right of acceptance. If accepted, the counter-offer becomes a valid contract provided all other requirements are met. S24. A. May be assigned. A real estate contract that is not a personal contract for services can be assigned to another party unless the terms of the agreement specifically prohibit assignment. Listing agreements, for example, are not assignable, since they are personal service agreements between agent and principal. Sales contracts, however, are assignable, because they involve the purchase of real property rather than a personal service. S25. C. A 2-year lease. A contract may be in writing or it may be an oral, or parole, contract. Certain oral contracts are valid and enforceable, others are not enforceable, even if valid. For example, most states require listing agreements, sales contracts, and leases exceeding 1 year to be in writing to be enforceable. S26. B. A dual agent. Dual agency occurs whenever a single broker represents both principal parties to a transaction. Here, since Bob and Sue work for Bill, Bill is the dual agent. S27. A. Upon first substantive communication. The agent must provide written notice to all parties or their agents as soon as substantive communication occurs, which can include initial face-to-face contact. S28. D. Neither seller nor buyer. In recent years, the brokerage industry has striven to clear up the question of who works for whom, and who owes fiduciary duties to whom. One solution allows a broker to represent no one in a transaction. That is, the broker acts as a transaction broker or facilitator and has no allegiance to buyer or seller. S29. B. The principal has proposed an illegal act, which should not be obeyed. An agent must comply with the client's directions and instructions, provided they are legal. If the directive is illegal, the agent must also immediately withdraw. S30. B. Negotiated with clients. The amount of a broker's commission is whatever amount the client and broker have agreed to. S31. B. The client may be liable for a commission and marketing expenses. With an exclusive right to sell listing, if the property sells during the term of the revoked listing, the client is liable for the commission. If the property does not sell, the client is liable for the broker's actual costs. S32. B. The agent has a claim to a commission if the owner sells or leases to a party within a certain time following the listing's expiration. Many listings include a protection clause stating that, for a certain period after expiration, the owner is liable for the commission if the property sells to a party that the broker procured, unless the seller has since listed the property with another broker. S33. C. The advertising must not be deceptive. Advertising may not be misleading or deceptive in promoting the brokerage or listed properties. Blind ads are also prohibited without exception. Salespersons, moreover, must identify their employer. S34. A. Collusion. Collusion is the illegal practice of two or more businesses joining forces or making joint decisions which have the effect of putting another business at a competitive disadvantage. S35. B. The brokers have illegally fixed prices. Price fixing is the practice of two or more brokers agreeing to charge certain commission rates or fees for their services, regardless of market conditions or competitors. S36. A. The seller may cancel the contract, since it can be ruled invalid. A contingency that is too broad, vague, or excessive in duration may invalidate the entire contract on the grounds of insufficiency of mutual agreement. To avoid problems, the statement of a contingency should be explicit and clear, have an expiration date, and expressly require diligence in the effort to fulfill the requirement. S37. D. Claim the deposit as compensated damages for the buyer's failure to perform. If a buyer fails to perform under the terms of a sale contract, the breach entitles the seller to legal recourse for damages. The usual remedy is forfeiture of the buyer's deposit as liquidated damages, provided the deposit is not grossly in excess of the seller's actual damages. S38. B. The optioner must perform if the optionee takes the option, but the optionee is under no obligation to do so. An option to buy places the optionee under no obligation to purchase the property. However, the seller must perform under the terms of the contract if the buyer exercises the option. An option is thus a unilateral agreement. Exercise of the option creates a bilateral sale contract where both parties are bound to perform. S39. B. A decline in demand for all types of real estate in the real estate market. Businesses that support the departing company will lay off or fire new employees, causing some to leave town in search of work. Some of these businesses may also have to cease operations. Hence the demand for residential real estate, as well as for commercial and industrial, will decline, and new construction will probably also halt until some other factor increases demand again. S40. B. Rental prices in that market will rise. An undersupply of commercial properties in relation to demand will most likely increase prices, as renters have fewer choices and less bargaining power. S41. B. Absorption. Absorption is the amount of available property that becomes occupied over a period of time, usually measured in square feet. S42. B. $17,000. First derive the annual depreciation, which is the cost divided by the economic life. Then multiply annual depreciation times the number of years to identify total depreciation. Remember to subtract depreciation from the original cost if the question asks for the ending value. Thus, $20,000 divided by 20 years x 3 years, equals $3,000 total depreciation. The ending value is $20,000 to $3,000, or $17,000. S43. B. Apartment buildings. The income capitalization approach, or income approach, is used for income properties and sometimes for other properties in a rental market where the appraiser can find rental data. The approach is based on the principle of anticipation. The expected future income stream of a property underlies what an investor will pay for the property. S44. C. Estimates net income and applies a capitalization rate to it. The steps are: estimate potential gross income, estimate effective gross income, potential minus vacancy and credit losses, estimate net operating income, effective minus total operating expenses, select a capitalization rate, and apply the capitalization rate. Use the formula, income divided by cap rate equals value. S45. C. Potential gross income minus vacancy and credit loss minus expenses. Net operating income, or NOI, is always income after vacancy, credit loss, and expenses. It does not, however, include debt service. S46. B. $400,000. Value equals income divided by cap rate. Thus, V equals $40,000 divided by 0.10 equals $400,000. S47. A. The interest rate may vary. Adjustable rate mortgages, ARMs, allow the lender to change the interest rate at specified intervals and by a specified amount. Federal regulations place limits on incremental interest rate increases and on the total amount by which the rate may be increased over the loan term. S48. B. A wraparound lender can profit when the interest rate of the wraparound exceeds that of the underlying mortgage. In a wraparound loan arrangement, the seller receives a junior mortgage from the buyer, and uses the buyer's payments to make the payments on the original first mortgage. This potentially enables the seller to profit from any difference between a lower interest rate on the senior loan and a higher rate on the wraparound loan. S49. B. A blanket mortgage loan. A blanket mortgage is secured by more than one property, such as multiple parcels of real estate in a development. S50. B. Payments are not sufficient to retire the loan. Negative amortization causes the loan balance to increase over the term. This occurs if the borrower's periodic payment is insufficient to cover the interest owed for the period. The lender adds the amount of unpaid interest to the borrower's loan balance. S51. B. The loan amount needs to be less than the property's value. Lenders must have a margin of borrower equity to protect against falling real estate values which increase the risk of the loan. Without this margin, a lender can incur a loan loss in a foreclosure sale since the proceeds may be less than the loan amount. S52. B. Truth in lending laws. Truth in lending laws, implemented by the Federal Reserve's regulations regulate the disclosure of costs, the right to rescind the credit transaction, advertising credit offers, and penalties for non-compliance with the Act. S53. D. Participants sell mortgage-backed securities in order to buy pools of loans. Secondary mortgage market organizations buy pools of mortgages from primary lenders and sell securities backed by these pooled mortgages to investors. By selling securities, the secondary market brings investor money into the mortgage market. By purchasing loans from primary lenders, the secondary market returns funds to the primary lenders, thereby enabling the primary lender to originate more mortgage loans. S54. A. Cost recovery expense. Cash flow is the difference between the amount of actual cash flowing into the investment as revenue and out of the investment for expenses, debt service, and all other items. Cash flow concerns cash items only, and therefore excludes depreciation, cost recovery, which is not a cash expense. S55. C. Dividing net income by the price paid for the property. The investment return measure known as return on investment, ROI, is calculated by dividing net income by the value of the investment. This yields a rate of return on investment. S56. A. Installing a higher capacity air conditioning and purifying system. Basis is increased by the cost of capital improvements made to the property. Examples of capital improvements are putting on an addition, paving a driveway, replacing a roof, adding central air conditioning, and rewiring the home. Repairs, maintenance, and redecorating are not generally considered capital improvements. S57. C. There are no federal ad valorem taxes on real property. There are no federal taxes on real property. The Constitution of the United States specifically prohibits such taxes. The federal government does, however, tax income derived from real property and gains realized on the sale of real property. S58. B. The assessed value of property. General property taxes are levied on an ad valorem basis, meaning that they are based on the assessed value of the property. Assessed value is determined according to state law, usually by a county or township assessor or appraiser. S59. D. The prohibition may be legal if performed correctly. The condominium association may be exempt from fair housing prohibitions against age discrimination if it is established as a retirement community in which 80% of the dwellings have one person who is 55 years of age or older and it has amenities for elderly residents. S60. C. The agent and the owner. The owner has illegally discriminated, and the agent, by going along with the owner, is equally guilty of violating fair housing laws. S61. B. Inspection fees. Prorated items are expenses that both parties must share. Non-prorated items are one-time individual charges such as sale commissions, recording fees, and title insurance. S62. D. a lender paying a fee to a broker for referring a borrower to the lender. RESPA prohibits the payment of fees as part of a real estate settlement when no services are actually rendered. This prohibition includes referral fees for such services as title searches, title insurance, mortgage loans, appraisals, credit reports, inspections, surveys, and legal services. S63. B. Copies of required communications to principals. Some communications with transaction parties are good and necessary for business. Others are required by law, and records of them must be maintained for a statutory period. Required records typically include listing agreements, offers, contracts, closing statements, agency agreements, disclosure documents, correspondence and other communication records, notes and any other relevant information. S64. A. Refuse to use terms that refer to or describe any of the classes of persons protected by the laws. Before entering into a listing agreement, a licensee should explain that it is necessary to comply with fair housing laws and obtain the potential client's acknowledgement and agreement. The agent should make it clear that the agent will reject the use of terms indicating race, religion, creed, color, national origin, sex, handicap, age, or familial status to describe prospective buyers. Such terms should be avoided in conversation as well as in advertising. S65. A. Alterations to a rental space made to fit a particular tenant. Alterations made specifically for certain tenants are called build-outs or tenant improvements. The work may involve merely painting and recarpeting a rental space, or erecting new walls and installing special electrical or other systems. S66. C. Maintain a special trust account in a qualified financial depository. State laws and real estate commission rules specify how a property manager is to manage trust funds. In general, the agent is to maintain a separate bank account for these funds, with special accounting, in a qualified depository institution. The rules for how long an agent may hold trust funds before depositing them, and how the funds are to be disbursed, are spelled out. The fundamental requirements are that the owners of all funds must be identified, and there must be no commingling or conversion of client funds and agent funds. S67. C. 3. The total area of the living room is 8x14 plus 8x18 plus 8x16 plus 8x18, equals 528 sf. They will therefore need 528/200 sf, or 3 whole gallons. S68. D. 218. Since the investor paid $100,000 total, and that equals $250 per frontage foot, there are 400 frontage feet, 100,000/250. If the property is 2 acres, it totals 87,120 sf. Dividing this by 400 produces a lot depth of 217.8. S69. C. Yes, with $360 left over. The loan she can get amounts to $240,000 x 80%, or $192,000. The points charge is $192,000 x .02 or $3,840. Total closing costs are then $3,840 plus $800 or $4,640. Thus she has $360 to spare. S70. C. $90,000 first. The sale price is 115% of the appraised value, so the appraised value is $230,000/115%, or $200,000. The lender will lend $140,000, 70% of appraised value, so the investor will have to come up with $90,000, $230,000 to $140,000. S71. C. $96,000. Since the comparable has an extra half bath, it is adjusted downward to equalize with the subject. Conversely, since it has no patio, the appraiser adds value to the comparable. Thus, $100,000 minus $5,000 plus $1,000 equals $96,000. S72. C. $508. The total assessed value is $84,550 plus $235,000, or $319,550. The annual tax is based on $319,550/100 equals 3,195.51 Round up to 3,196. To derive the annual tax, multiply 3,196 x 1.91, or $6,104.36. Divide this by 12 for the monthly escrow, $6,104/12, equals $508. S73. D. $92,000. The formula for equity is current value, indebtedness. The current value is $180,000 plus 25% x 180,000, or $180,000 x 125%, or $225,000. The current debt is $180,000 x 80%, $11,000, or $133,000. Their equity is therefore $92,000. S74. B. $166,150. Use the formula, gain equals, net selling price, adjusted basis, where adjusted basis equals, beginning cost, depreciation. The selling price is $240,000 x 5% annual appreciation x 10 years, or $240,000 plus 50% x 240,000, or $360,000. Since land cannot be depreciated, the depreciable basis is $240,000 total cost, $60,000 land value, or $180,000, land equals 25% total value. Annual depreciation equals $180,000/39 years, or $4,615. Thus total depreciation is $4,615 x 10 years, or $46,150. The adjusted basis is therefore $240,000 to $46,150, or $193,850. The total gain is therefore $360,000 to $193,850, or $166,150. S75. C. $80,000. Applying the formula, percent of insurable property value carried / 80% replacement cost, X claim equals recovery, divide the amount of coverage carried, $160,000, by 80% of the insurable property value, $250,000, to get the percent of the claim the company will pay, 80%. Multiply this percentage by the claim amount to get $80,000, what the company will pay. S76. B. 3 years as a Nevada real estate broker or 5 years as a broker salesperson. A Nevada real estate commissioner must be a broker or a broker salesperson. A broker must have 3 years of active experience immediately preceding appointment, and a broker salesperson must have 5 years of active experience immediately preceding appointment. The residence requirement is 5 years. S77. A. No. Lacking a real estate license, Jerry cannot claim payment for performing the services of a real estate licensee. An agreement to pay an unlicensed person is unenforceable. S78. B. A real estate license and a special permit. Property management is one of the special areas of practice that requires a real estate license and a special permit. A license alone is not sufficient. Certification by an association is helpful, but does not meet the requirement. S79. B. Performing activities that do not require a license. The person with an inactive license cannot engage in any activities that require a license. Showing listings, working as a salesperson, and assisting buyers prepare offers require a real estate. S80. D. At least 10 days before the close of escrow. The seller's real property disclosure form must be delivered to the buyer, by law, at least 10 days before the close of escrow. This time period is often shortened by agreement of the parties. S81. C. 4 working days. The buyer's rescission period is 4 working days after receipt of the seller's real property. S82. C. Give the buyer written notice that the crack has worsened if, after delivery of the seller's real property disclosure form, a new defect is discovered, or a disclosed defect has worsened. The seller must disclose the change to the buyer in writing before conveyance of the property. S83. D. Resale package. The resale package is required in all residential resale transactions where the property is located in a common interest community. The resale package is in addition to, and not in lieu of, the seller's real property disclosure form. S84, A. Open range disclosure. When property is located adjacent to the land where domesticated animals are allowed to roam or graze, the seller must give to the buyer, before the buyer signs an offer, an open range disclosure form. S85, C. 5 years. A real estate broker must retain real estate transaction records for 5 years. S86, C. 5 calendar days. A salesperson or broker salesperson must provide any paperwork to the broker with whom she is associated within 5 calendar days after that paperwork is executed by all the parties. S87, C. 30 days of receipt of the monthly bank statement. Trust accounts must be reconciled monthly within 30 days after receipt of the bank statement. S88, D. No. Any real estate licensee may prepare a broker price opinion. Although it is called a broker price opinion, it can be prepared by any real estate licensee. S89, A. 1 business day. A licensee must give the broker or escrow holder the earnest money within 1 business day. The broker has until the next banking day to deposit the money in the broker's trust account. S90, D. Pay some or all of it to the seller. Although it is rarely done, unless the purchase agreement provides otherwise, a broker can pay all or a portion of an earnest money deposit to a seller. S91, A. The name of Sophia's brokerage. In all real estate advertising, the name of the brokerage firm must be disclosed. The other items are typically included but not legally required. S92, D. Francis Cretin. In advertising, a licensee may use only his licensed name. Nicknames are not allowed. S93, D. Include the name of the brokerage firm. Advertising on the Internet is subject to the same regulations as print advertising and therefore must include the name of the brokerage. S94, C. Jenny. A broker salesperson. A real estate broker may use a real estate broker salesperson to assist in administering the office, as long as the broker does not relinquish overall responsibility. There is no experience requirement for the broker salesperson. A salesperson may not be used to assist in administering the office. S95, B. A statement that all associated licensees are subject to the broker's supervision. A broker can enter an independent contractor agreement with an associated licensee, but that agreement must include the supervision of the broker over the licensees. S96, B. The payment is a violation. Only the broker can pay Osgood. Referral fees among real estate licensees are legal in Nevada. However, a licensee can only be compensated by the broker or owner-developer with whom the licensee is associated. Payment of the referral fee in this case should have flowed through the broker. S97, A. Duties owed by a Nevada real estate licensee form. The duties owed by a Nevada real estate licensee form must be given to each client and any unrepresented party to the transaction. A for sale by owner seller is an unrepresented party to the transaction. S98, C. Just the fact that the parents are paying the commission, a real estate licensee is required to disclose each source of compensation but is not required to disclose the amount. Since the disclosure is required by law, the information cannot be confidential. S99, A. Yes. She must disclose material facts concerning the transaction. A licensee owes a duty to her client to disclose material facts she knows concerning the transaction. There is no duty of confidentiality owed to a non-client. S100, A. Max land divided into or proposed to be divided into 35 or more lots is subject to the subdivided land law. Acreage is not relevant. Appendix, useful websites. Nevada Real Estate.